happy that I have got an opportunity like this to talk about international environment law, and I hope that this discussion or class will help us appreciate more, or it will either re-emphasize what we have already had or learned, or it will turn into a tool that you'll always look at to refresh your memory on certain aspects, especially in international environment law. As you will know, I have already, in the various classes that we have had, I have already decided and we have introduced ourselves to what is environment. And in this particular case, the kind of law that we are going to look at is that relates to interstate issues or interstate parties. And for that matter, we hope that this discussion or engagement will support the overarching aspects that we know already. Now, international law, you could also take it to mean matters between or among states. And in this case, the matters that we're talking about relate to the environment. And when we talk about the environment, I will encourage you to look at the different spheres that make up the environment. And those spheres that make up the environment, some of which are the atmosphere, which means that international law will be relating in this case to aspects to do with our air that we share. And I hope you'll appreciate that there's what they call transboundary pollution. So, atmosphere, yes. Then there's also what they call biosphere, the living, right? Which includes the flora and the fauna, the plants and the animals. There's also the hydrosphere, which relates to water. There's also the lithosphere, which is the soil. And the others, I encourage you to help appreciate. So we are basically talking about those kind of resources that are owned as globally common, that they are of good interest or key interest to the international environment. It is important for you to appreciate that international law looks at states because these states, governments are sovereign. They are independent. They are creatures of constitutions, whether those constitutions are written or not written. So widespread concern about the need for global action for the protection of the natural environment is a relatively recent phenomenon. General public awareness of the problems relating to the global environment and the need for coordinated multilateral action to address these problems was not evident even in a few decades ago. So with the wider dissemination of information relating to ever-increasing environmental challenges, international concern has grown steadily over the years. Some interstate efforts to address environment-related problems to the oceans, to endangered species, and other natural resources date back to the 19th century. But many problem areas relating to the environment remain to be addressed. So the course that we are studying, whether it responded to issues that are just present over and again, environmental issues continue to come up, and that's why dissemination of such information is key. And this, of course, justifies why we are studying international environment law, international conventions for natural resources, which means that these are tools, the conventions, the international laws that have been adopted to try to address non-compliance or disregard or the wanton exploitation or impunity that has come up with international players. So it is important that these early international efforts that were relatively uncoordinated. And now what does the international intervention, the current one, come in? So modern international environmental law received a major boost with the 1972 United Nations Conference on the Human Environment, which was held in Stockholm, Sweden, which brought much broader attention to the issues. So in order to understand the international environment law, it is necessary to have a basic grasp of general international law. International environment law is a subject of international law, and international law has been developing over a long period of time. Since a significant part of international environment law is incorporated in multilateral environmental agreements, an introduction to a treaty law is essential for understanding the contents. So in addition to exploring the basic principles relating to the law on treaties, it is important that we discuss or we distill the multilateral environmental agreements. So while every effort will be made to the factual guidance on the sources of international law, it is incumbent on me to do, due to obvious space constraints and to the limited objectives, and of course also the time constraints, the resource constraint, and because I'm making a short video which ought to be small, it is important for me to have a summary. But now this is what is important. We are going to start with the sources of international law. The principal judicial organ of the United Nations is the International Court of Justice. The jurisdiction of the International Court of Justice is specified well in Article 36, Clause 1 of its statute. Comprises all cases which the parties refer to it and all matters specifically provided in the Charter to the United Nations or in the treaties and conventions in force. So the United Nations Charter further stipulates that all members of the United Nations are ipso facto parties to the International Court of Justice Statute. Article 39 says the same. Besides decisions, the International Court of Justice is authorized to render advisory opinions on any legal question. So when requested by the General Assembly or the Security Council, other organs of the United Nations and specialized agencies may also request advisory opinions of the International Court of Justice on legal questions arising within the scope of their activities. When authorized by the United Nations General Assembly in Article 96. So the International Court of Justice, by the very nature of its functions, plays an important role in the development of international law. Accordingly, the sources of law relied upon by the International Court of Justice are pertinent when examining the sources of international law and consequently international environment law. Article 38, Clause 1 of this statute, that is the ICJ statute, ICJ, I mean International Court of Justice statute, the statute which creates the International Court of Justice, as I have already said, and its functions, may rely upon to determine the law applicable to a case brought to its attention. I repeat that Article 38, Clause 1 of the statute of the ICJ lists the four sources that the International Court of Justice may rely upon to determine the law applicable to a case brought before its attention. And these four, of course, will speak to the different sources of international law. So the sources listed in Article 38, Clause 1 are regarded as the authoritative sources of international law and thus also of international environment law. So the statute of the International Court of Justice, Article 38, reads as I am going to read verbatim and quote. The court, whose function is to decide in accordance with international law, such disputes as are subject to it shall apply. A. International conventions, where general or particularly establishing rules expressly recognized by the contesting parties. Now, when I talk about examples of international conventions, One of them is the Ramza Convention. And the Ramza Convention, of course, is the one that was formed in Ramza. And when it was so formed in Ramza, then it had objectives, and those objectives are intended to protect wetlands or water sources, and of course with their species. And the example I always give is the Rutembe Beach, which is a Ramsar site. And in Masaka, there is also Nabugabo Sea, which is equally a Ramsar site. And that is in as far as conventions are concerned. The other conventions, of course, we shall list them in the subsequent classes or as we proceed. So the international conventions is one of those. International customs, traditions, and practices as evidence of a general practice accepted as law. The third is the general principle of law recognized by civilized nations. General principles of law recognized by civilized nations. And like I said, some of them that are to do with sovereignty, domestication, signing, and the like. Subject to the provisions of Article 59, judicial decisions and the teachings of most highly qualified publications of various nations as subsidiary means for the determinations of rulers of law. Now, in this particular case, judgments are judicial decisions. Judicial decisions could be responses to petitions, could be declarations, could be convictions, could be awards. So whatever the judiciary says ultimately becomes a judicial pronouncement. And for as long as it remains on the record of court, it becomes precedence to guide any similar matters that will ever arise. And if they ever did, they will become res judicata, which means that they have already been decided, and their application on how they are dealt with will be as the decision that was made then. And those also issues of precedence, also there's authoritative precedence and the persuasive precedence. So it is also incumbent on which court is applying which precedent. And a subordinate court may not find itself within the ambit or the ambit or the jurisdiction of this particular okay. So it is important that they apply what was decided, for as long as it does not in a way or the other conflict with the court. So the other aspect that I wanted to talk about is that Article 38 establishes a practical hierarchy of sources of international law in settling of disputes. First, relevant treaty provisions applicable between the parties of the dispute must be employed. In the event that there are no applicable treaty provisions, rules of customary international law should be applied. If neither a treaty provision nor a customary rule of international law can be applied or can be identified, then reliance should be placed on the general principles of law recognized by civilized nations. Finally, judicial decisions and writings of highly qualified jurists, scholars, such as peer-reviewed journals, law reports, dictionaries, those and textbooks, those form the kind of classical work or writings that I'm talking about. And of course, as subsidiary means of determining the dispute. It is important to remember that in many cases, due to the absence of any ambiguous rules, the International Court of Justice has had to rely on multiple sources. So Article 38, still again, of the International Court of Justice, subsection 1, paragraph A, B, and C are the main sources of international law and the international environment law. However, given the uncertainties that prevail Article 38, Clause 1, Paragraph D also becomes a significant source in this area of law. And that's what we are talking about. So now it is important for us to talk about the law of the treaties. Treaties are the major mechanism employed by states in the conduct of their relations with each other. Like I did say, that international law is basically cooperation, international cooperation. How do you relate? Which resource do you share? And how do you interact? So today, treaties are the major mechanism employed by states in conducting their relations with the other. They provide the framework of modern international relations and is the main source of international law. The starting point for determining what constitutes a treaty is to be found in a treaty itself. The Vienna Convention on the Law of Treaties, which is also called a treaty on treaty law. It was concluded in 1969 and entered into force in 1980. That is 1969 Vienna Convention is its name. So while the United Nations had 191 member states, the 1969 Vienna Convention has only 105 parties as of September 2005. A treaty is binding only among its parties. Although the 1969 Vienna Convention is not a treaty with global participation, it is widely acknowledged that many of its provisions have codified existing customary international law. Other provisions may have acquired customary international law status. Since customary international law and treaty law have the same status as international law, many provisions of the 1969 Vienna Convention are considered to be binding on all states. A reliable source of practical information on a treaty law and practice is the Treaty Handbook, which is accessible through the internet on or at www.untreaty.un.org, prepared by the Treaty Section of the United Nations Office of the Legal Affairs. Although mainly designed for the use of government officials and others involved in assisting governments on the technical aspects of participation in treaties deposited with the United Nations Secretary General and the registration of treaties pursuant to Article 102 of the Charter of the United Nations, it is of use to anyone interested in the United Nations, or it is of use to anyone who would be having an interest in treaty law and its practice. So it is worth your reading, but also of interest. So Article 2, Clause 1, Paragraph A of the 1969 Vienna Convention defines a treaty as an international agreement concluded between states in written form and governed by international law, whether embodied in a single instrument or in two or more related instruments, whatever its particular designation. I repeat, Article 2, Clause 1, Paragraph A of the 1969 Vienna Convention defines a treaty as an international agreement concluded between states, whether in written form or governed by international law, embodied either in a single instrument or in two or more related instruments, and whatever its particular designation. So according to the designation employed in a document does not determine whether it is a treaty. Regardless of the designation, an international agreement falling under the above definition is considered to be a treaty. So the term treaty is a generic name. The term treaty encompasses, among others, the terms conventions, agreements, pact, protocol, charter, statute, covenant, engagement, accord, exchange of notes, modus vivendi, and memorandum of understanding. All those terms that I've talked about connote, denote, or speak like or you could relate to them for as long as they are having aspects of international relations, then they fall in the category of what a treaty will be. Just like I did say already, treaty is just a generic name. As long as an instrument falls under the above definition, it would be considered to be a treaty and therefore binding under international law. International organizations are also recognized as capable of concluding treaties depending on their constituent instruments. So occasionally, some of these terms employed by drafters and negotiators may suggest other meanings without much consideration for their traditionally acceptable meanings. That is, they may also be used to mean something other than treaties, which on occasion makes treaty terminology confusing and interpretation a problem. So the terms, like I have said already, may vary because they are often employed to indicate different degrees of political or practical significance. For example, a simple bilateral agreement on technical or administrative cooperation will relatively be designated to mean a covenant or a charter, whereas an agreement establishing an international organization will usually not be given such labels as agreed minutes or memorandum of understanding. So, the nature of labeling used to describe an international agreement may say something about its content, although this is not always the case. The two principal categories of treaties are the bilateral and the multilateral agreements, the former having only two parties and the latter at least two, and often involving global participation. So the term treaty can be used as a generic term or as a specific term which indicates an instrument with certain characteristics. There are no consistent rules to determine when state practice employs the term treaty as a title of an international instrument, although in practice of certain countries, the term treaty indicates an agreement or of a more solemn nature and is reserved for regulating matters of some gravity. So in the case of bilateral agreements, affixed signatures are usually sealed. Typical examples of international instruments designed as treaties include peace treaties, border treaties, delimited treaties, extradition treaties, treaties of friendship, commerce, and cooperation. So the designation convention and agreement appear to be more widely used today in the case of multilateral environmental instruments. So the term agreement can also have a generic and specific meaning. The term international environment in its generic sense embraces the widest range of international instruments. In the practice of certain countries, the term agreement invariably signifies a treaty. Agreement as a particular term usually signifies an instrument less formal than a treaty and deals with a narrower range of subject matter. So there is a general tendency to apply the term agreement to bilateral or restricted multilateral treaties. It is employed especially for instruments of a technical or administrative nature, which are signed by representatives of government, departments, and are not subject to ratification. Typical agreements deal with matters of economic, cultural, scientific, and technical cooperation and financial matters such as avoidance of double taxation. Especially in international economic law, the term agreement is also used to describe broader multilateral agreements. For example, the commodity agreement. Today, the majority of international environment instruments are designated as agreements. And this, of course, we shall speak and expound about when we are talking about the soft law and the hard law. The term convention can also be both a generic and a specific meaning. The generic term convention is synonymous with the generic term treaty. With regard to convention as a specific term, In the last century, it was regularly employed for bilateral agreements, but now it is generally used to form multilateral treaties with a broad range of parties. Conventions are normally open for participation by the international community as a whole or by a larger number of states. Usually, the instruments negotiated under the auspices of the United Nations are entitled conventions. For example, the 1992 Convention on Biodiversity and the 1982 United Nations Convention on the Law of the Sea. Because of many international instruments in the field of environment and sustainable development are negotiated under the auspices of the United Nations, many instruments in those areas are called conventions, such as the World Health Organization, the World Health Organization Framework Convention on Tobacco Control, the United Nations Framework Convention on Climate Change. So, the United Nations Convention to combat desertification in countries experiencing serious drought and or desertification, particularly in Africa, and the 2001 Convention on Persistent Organic Pollutants are among the examples I can give. It's also important for me to talk about the term charter is used particularly to form the solemn instruments, such as the constituent treatment of an international organization. The term itself has an emotive content that goes to the back, that goes back to the Magna Carta of 1215. More recent examples include the 1945 Charter of the United Nations, the 1963 Charter of the Organization of African Unity, and the 1981 African Banjul Charter on Human and People's Rights. The 1982 World Charter on Nature is a resolution adopted by the United Nations General Assembly and is not a treaty. And treaty, I have, rather, in as far as the charter is concerned, now allow me also to talk about the term protocol. The term protocol is used for examples less formal than those entitled treaty or convention, but they also possess the same legal force. A protocol signifies an instrument that creates legal binding obligations at international law, and in most cases, this term encompasses an instrument which is subsidiary to a treaty. The term is used to cover, among others, the following instruments. An optional protocol to a treaty is an instrument that establishes additional rights and obligations with regard to a treaty. Parties to the main treaty are not obliged to become party to an optional protocol. An optional protocol is sometimes adopted on the same day as the main treaty, but is of independent character and subject to independent signature and ratification. Such protocols enable certain parties to the treaty to establish among themselves a framework of obligations with reach further than the main treaty, and to which not all parties of the main treaty consent, creating a two-tier system. An example is found in the optional protocols to the 1966 International Convention on Civil and Political Rights. The first optional protocol of which deals with the direct access for individuals to the committee established under it. A protocol can be a supplementary treaty. In this case, it is an instrument which contains supplementary provisions to previous treaties. For example, the 1966 protocol relating to the status of refugees, to the 1951 convention relating to the status of refugees. A protocol can be based on the further elaborate or can be based on and further elaborate, a framework convention. The framework umbrella convention, which sees general objectives, contains the most fundamental rules of a more general character, both procedural and substantive. So these objectives are subsequently elaborated by a protocol with specific substantive obligations consistent with the rules agreed upon in the framework treaty. So this structure is known as the so-called framework protocol approach. Examples include the 1985 Vienna Convention for the protection of the ozone layer and the 1987 Montreal Protocol on substances that deplete the ozone layer with its subsequent amendments. The 1992 United Nations Framework Convention on Climate Change with its 1995 Kyoto Protocol and the 1992 Convention on the Protection and Use of Transboundary Watercourses and International Lakes with its 1999 Protocol on Water and Health and its 2003 Kiev Protocol on Civil Liability and Compensation for Damage Caused by the Transboundary Effects of Industrial Accidents on Transboundary Waters. A protocol of signature is another instrument subsidiary to a main treaty and is drawn up by the same parties. Such a protocol deals with additional matters such as the interpretation of particular clauses of the treaty. Ratification of the treaty will normally also involve ratification of such a protocol. The protocol provisions, application of the General Agreement on Tariffs and Trade, GATT, General Agreement on Tariffs and Trade, GATT, was concluded to bring the 1947 GATT quickly into force in view of the difficulties facing the ratification of the International Trade Organization. The term declaration is the other one that I thought is also important for us to also know. You must appreciate that in this particular discussion, I'm talking about the different terms, the different documentations or treaties that are within the realm of international law as and how used or as and how applicable, but ultimately all meaning that they serve the same role of international law. So the term declaration is used to describe various international instruments. However, in most cases, declarations are not legally binding. The term is often deliberately chosen to indicate that the parties do not intend to create binding obligations, but merely seek to declare certain aspirations. Examples include the 1992 Rio Declaration on Environment and Development, the 2002 United Nations Millennium Declaration, and the 2002 Johannesburg Declaration on Sustainable Development. Exceptionally, declarations may sometimes be treaties in the generic sense intended to be binding at international law. An example is the 1984 Joint Declaration of the Government of the United Kingdom of Great Britain and North Ireland and the Government of the People's Republic of China on the question of Hong Kong, which was registered as a treaty by both parties with the United Nations Secretariat, pursuant to Article 102 of the United Nations Charter. It is therefore necessary to establish in each individual case whether the parties intended to create binding obligations, often a difficult task. Some instruments entitled declarations were not originally intended to be binding, or rather having binding force, but their provisions may have reflected customary international law or may have gained binding character as customary international law at a later stage, as is the case with the 1948 Universal Declaration on Human Rights. Once the text of a treaty is agreed upon, states indicate their intention to undertake measures to express their consent to be bound by the treaty. Signing the treaty usually achieves this kind of purpose, and a state that signs a treaty is a signatory to the treaty. Signature also authenticates the text and is a voluntary act. Often major treaties are open for signature amidst much pomp and ceremony. The United Nations Treaties section organizes major themes-based treaty events in conjunction with the Annual General Assembly of the United Nations to encourage wider participation in the treaties deposited with the Secretary General. The events tend to encourage states to undertake treaty actions in much larger numbers than usual. Once a treaty is signed, customary law, as well as the 1969 Vienna Convention, provides that a state must not act contrary to the object and purpose of the particular treaty, even if it is not entered into force yet. So 1996 Vienna Convention on the Law of Treaties, Article 18. A state is obliged to remain, or rather, a state is obliged to refrain from acts which would defeat the object and purpose of the treaty when A. It was signed, rather it has signed the treaty or has exchanged instruments constituting the treaty subject to ratification, acceptance, or approval until it shall have made its intention clear not to become a party to the treaty, or B. It has expressed its consent to be bound by the treaty pending the entry into force of the treaty and provided that such entry into force is not unduly delayed. So the next step is the ratification of the treaty. Bilateral treaties, often dealing with more routine and less politicized matters, do not normally require ratification and are brought into force by defining signature without recourse to the additional procedures of ratification. So 1969 Vienna Convention of the Treaties, or the Law of Treaties, Article 12, the consent of a state to be bound by a treaty is expressed by the signature of its representative when the treaty provides that signature shall have that effect. B. It is otherwise established that the negotiating states were agreed that signature should have that effect. Or C. The intention of the state to give that effect to the signature appears from the full powers of its representative or was expressed during the negotiation. So in the first instance, the signatory state is required to comply with its constitutional and other domestic legal requirements in order to ratify the treaty. So this act of ratification, depending on domestic legal provisions, may have to be approved by the legislature, parliament, the head of state, or similar entity. It is important to distinguish between the act of domestic ratification and the act of international ratification. So once the domestic legal requirements are satisfied, in order to undertake the international act of ratification, the state concerned must formally inform the other parties to the treaty of its commitment to undertake the binding obligations under the treaty. In case of a multilateral treaty, this constitutes submitting a formal instrument signed by the head of state or government or the Minister of Foreign Affairs to the depositary, who in turn informs other parties. With ratification, a signatory state expresses its consent to be bound by the treaty. Instead of ratification, it can also use the mechanism of acceptance or approval depending on its domestic, legal, or policy requirement. A non-signatory state which wishes to join the treaty after its entry into force usually does not do by lodging an instrument of accession, reflecting a recent development in international law. Some modern treaties, such as the 1997 Convention on the Prohibition of Use, Stockpiling, Production, and Transfer of Anti-Personnel Mines, and on their destruction, makes it possible for accession from the date of opening of this signature. Now, I have I have for sure tried to delve into certain aspects of international law in relation to the environment, and I encourage you to pursue this, read, interest yourself, look at the various examples that relate to the environment, and when you so do, I can guarantee you that you will have appreciated most of the aspects which speak to formulation, which speaks to um, domestication, which also speak to you being a party to the international laws. I am grateful that you have listened to the end, and I hope this was not too fast. You can always bring it back and forth and then appreciate it most. I look forward to the time when we meet in class. Over to you. I am Talibita Moses. I'm the legal officer for Uganda National Health Consumers Organization, but I am a teaching consultant and a lecturer in the School of Sciences. Over to you. I owe you.